And he deserves it, doesn't he, Jono, if he gets it?
17th fifer. Can you believe it? It only seems like the other day he started his test career. That's you on the left, Manners.
You can be Kepler.
Yeah, Dale Stein's been brilliant, but he's had some wonderful catches behind the stumps as well. Boucher's taken a lot for him. There's Smith, Callis as well. He's a brilliant bowler, is Dale Steyn. Gets the ball to move away from the right-hander at serious pace. There it goes. Smith got him a defensive field. Try and get Michael Clark off strike and bowl to Peter Siddle. 17th fifer. It's just incredible what Dale Steyn has done, and you just hear he could be the fastest man to, what's it, 200 test wickets, 250 test wickets. If he picks up a few more this match.
Record holder is the great Australian fast bowler Dennis Lillee. It's an overused word, great, but it's certainly appropriate when you speak about Dennis Lillee. And I think, to be honest, Johnny might only be 28, but I think it's appropriate for Dale Steyn as well. Already. It wasn't a catch, but it was an outside edge.
The light roller was used this morning. They gave it a little cut, did Evan, the groundsman. Then Bennett, he got onto that roller and he pushed it up and down for a good 7 minutes. There definitely is still a tinge of green out there. There's a bit of cloud cover as well. So it's going to help the ball move around most of the day. Clark has hardly put a foot wrong. He's found gaps. He's timed the ball beautifully. He played a mist up front. He took a few blows, but once he got going, incredible driving he played yesterday. It's just a brilliant innings.
You mentioned Evan Flint, the groundsman.
Well, you're correct, Peter. The disciplinary committee of the ANC has just walked in. They are about to address journalists now to tell them what is going to happen. So presumably they have done everything that they were supposed to do, which is one, informing the people concerned, informing the ANC Youth League of the verdict. They were supposed to have done that before they got here, and they were also supposed to have told the Secretary General of the ANC what they are going to tell the public. So all those processes presumably have taken place, and they are now about to address the public. Let's go inside without wasting any more of your time.
Through the chair, Comrade Derek Hanekom. But let's just introduce all of them. The one on my extreme right is Comrade Phoebe Potgeret Gubule. Comrade Phoebe is a member of the NDC and a member of the NEC as well. We then have Comrade Collins, that you also know very well, an NEC member, but also a member of the NDC. We then have Comrade Susan, that you also know very well, a member of the NEC, but also a member of the National Disciplinary Committee as well. We then have the chair of the NDC, Comrade Derek Hanekom, who's also a member of the NEC. Then we have Comrade Ayanda Dlodlo, NEC member and also a member of the NDC. We have the last member, Comrade, the reason why I stopped a bit is because we always call him our wonderful, wonderful political commissar. But his Comrade Playfair. He's also a member of the NEC and a member of the NDC. Without any further ado, because this is a press conference of the National Disciplinary Committee, we'll then call upon the chair of the National Disciplinary Committee, Comrade Derek Hanekom, to speak to you. Comrade Hanekom.
Thank you very much. It's going to take a little bit of time because we think that having put in 10 weeks of work, we want to do justice to the work that has been done. We're going to start off by just giving you a preamble in the four cases that we've been dealing with. And the preamble, we say the ANC constitution requires public announcement of the outcome of a disciplinary proceeding. The purpose of this media conference is to announce the outcome of the disciplinary proceedings involving comrades Julius Malema, Ronald Lamola, Pule Mabe, Sindiso Magaka, and Kenetswe Mosenogi. Before dealing with the charges and findings, and in response to commentary and speculation by ANC members, political commentators, and the public, the National Disciplinary Committee wishes to contextualize the process and their considerations. Firstly, a few words on the ANC Constitution. In terms of the ANC Constitution, the NDC hears and decides cases referred to it by the ANC national officials, the National Working Committee of the ANC, or the NEC. There's been some confusion about this, and we think it's very important for us to clarify this. On the 16th of August, 2011, the ANC national officials, properly empowered in terms of the ANC Constitution, charged comrades Julius Malema, Ronald Lamola, Pule Mabe, Sindiso Magaka, and Kenetswe Mosenogi for violations of the ANC Constitution. Reasonable time was afforded to those charged and their representatives to prepare themselves for the hearings scheduled over the period 30th of August to the 6th of September 2011. Based on the facts and evidence presented, the NDC has made a ruling and decided on penalties. Those charged have been advised of the ruling and the penalties with reasons, and they have been advised of their right to appeal to the National Disciplinary Committee of Appeal. The NDC is accordingly satisfied that disciplinary proceedings were properly initiated and that proper process was followed. We want to say a few words about the prevailing circumstances during the hearing. The ANC's Constitution and Code of Conduct require members of the ANC to respect the Constitution and the structures of the ANC and to place their energies and skills at the disposal of the organization. Prior to the commencement of the disciplinary hearings, those charged, together with other national leaders of the ANC Youth League, addressed meetings of the ANC Youth League throughout the country, urging their members to support those charged. A specific call was made on the 23rd of August 2011 by the ANC Youth League Secretary General that, and I quote, "All young people in South Africa must come out in full support of our leaders because they are being charged for championing our demands and nationalization of mines." This call was followed by further support for those charged. At the House, causing disruption and chaos in the city of Johannesburg. Throughout the hearing, statements have been made on public platforms by some of those charged containing allegations and innuendo about the process of the disciplinary hearing, ulterior motives, and predetermined outcomes of the hearing. The rulings and penalties decided on by the National Disciplinary Committee are not determined by the circumstances and factors prevailing during the hearing. The NDC would like to remind all ANC members and leaders that the NDC is a structure appointed by the NEC of the ANC, tasked with the responsibility to consider any violation of the ANC Constitution based on the evidence before it. The rulings and penalties are determined by the NDC in private, whereafter the outcomes and disciplinary proceedings are reported to the Secretary General of the ANC and announced to the public. Just a few words on the aims and objectives of the African National Congress. The Constitution of the ANC sets out its aims and objectives and character in the preamble and in the rules of the Constitution. In particular, the preamble to the Constitution affirms that The fundamental goal of the ANC remains to construct a united, non-racial, non-sexist, democratic and prosperous society in South Africa. Rule 2 of the Constitution says that the aims and objectives, sets out the aims and objectives of the ANC. Rule 3, which describes the character of the ANC, contains clauses particularly pertinent to the charges considered. 3.4 states, the ANC shall, in its composition and functioning, be democratic, non-racial and non-sexist, and against any form of racial, tribalistic or ethnic exclusivism or chauvinism. 3.5 says, while striving for the maximum unity of purpose and functioning, the ANC will respect the linguistic, cultural and religious diversity of its members. 3.6 says the ANC will support the emancipation of women, combat sexism, and ensure that the voice of women is fully heard in the organization and that women are properly represented at all levels. 3.7 says the principles of freedom of speech and free circulation of ideas and information will operate within the ANC. The NDC then draws the attention of all ANC members and leaders at all levels in the organization to these clauses in particular, and reminds ANC members and leaders of the solemn commitment made at the time of joining the ANC to, and I quote, defend the unity and integrity of the organization and its principles and combat any tendency towards disruption and factionalism. I want to refer you to some of the decisions and resolutions of the third ANC National General Council, which took place from the 20th of September to the 24th of September in 2010, which directed that, and I quote, for the ANC to remain strong and effective, discipline is a non-negotiable that must be enforced at all levels of membership and leadership without fear or favor. On programmatic issues towards 2012, the conference said the following: the delegates overwhelmingly want the third National General Council to go down in history as the gathering that marked a decisive turning point in tackling, arresting and reversing the negative tendencies that have eroded or threatened to erode the political integrity and moral standing of the ANC among our people. The third National General Council has to be remembered as the gathering that went beyond condemning sins of incumbency and other misbehavior, such as ill discipline and factionalism. From now onwards, decisive action has to be taken by the leadership and membership to renew our movement and fight tenaciously against any tendency to erode the character, principle, core values, and culture of the ANC. On unity and cohesion of the movement, the National General Council said the following. It criticized the NEC for not being firm and consistent in enforcing discipline among all ANC members, including among NEC members. Acts of ill discipline in the constituent organs of the ANC, such as the leagues, and public attacks by our alliance partners have a direct negative bearing on the image and integrity of the ANC in society. Inconsistent application of rules and inactions were roundly condemned by the commissions. The NEC in particular and all constitutional structures in general are called upon to act with firmness, fairness and consistency in enforcing Rule 25 of the ANC Constitution. There should be no confusing signals and messages from the leadership on matters of discipline and integrity. And then finally, the declaration of the National General Council states that, and I quote, Council was frank in acknowledging that tendencies of ill discipline and misconduct had set in within various structures of the movement. This third National General Council, the delegates resolved, should mark a decisive turning point in addressing all the negative tendencies that eroded and posed danger of eroding the organizational integrity and very character of the ANC. In this regard, delegates stated without equivocation that there should not be confusing signals and messages from the leadership on matters of discipline. The responsibility to assert the core values and principles of our movement rests with every leader, every cadre, every member, and every supporter of the ANC. These are, amongst others, a steadfast adherence to the interests of the people, unity, selflessness, sacrifice, collective leadership, humility, honesty, discipline, hard work, internal debate, constructive criticism and self-criticism, and mutual respect. The current disciplinary proceeding are the first proceedings before the NDC following the NGC, and it is incumbent upon the National Disciplinary Committee to observe the injunctions of the National General Council. Argument was presented to the NDC by those charged that there must be consistency in dealing with matters of discipline, and the NDC concurs with this. Accordingly, all levels of leadership are urged to ensure that they indeed act with fairness, firmness, and consistency in addressing discipline in the organization. The NDC is also cognizant that those charged are national leaders of the ANC Youth League and is of the view that their leadership positions impose on them a responsibility to conduct themselves in all respects in an exemplary manner, serving as role models to young people. We now turn to the summary of the findings, and we start with the we'll deal with the 4 cases one at a time. 6 members of the ANC who are also members of the National Executive Committee of the ANC Youth League were charged with various acts of misconduct in terms of the ANC Constitution. 4 separate hearings were held between the 30th of August and the 6th of November 2011. The charged members requested that the findings in all 4 hearings be made at the end of the proceedings, which is what is happening now, which is what we did. This morning, all 6 respondents were informed of the findings against them. By agreement, the findings against Comrade Malema were presented to his representatives. Thereafter, the outcome of the hearings were reported to the Secretary General of the ANC, and this announcement to the public is in accordance with Rule 25.11 of the ANC Constitution. The findings in the 4 disciplinary hearings are lengthy. They run into 136 pages. A lot of complex matters were raised, and these have been deliberated on and have been ruled upon. The findings in each case follows a particular format. It provides, firstly, the details of the charges, secondly, the plea process, thirdly, summary of evidence of all witnesses and their cross-examination, fourthly, the onus of proof, 5, the determination of legal arguments raised by the respondents, 6, issues, and we list the issues that the NDC had to determine on, 7, we then present the determination of these issues by the NDC, 8, we list a number of factors that are considered in each case when determining an appropriate sentence, and we'll get to that when we get to the individual cases. And then there's a consideration of an appropriate penalty, and we give the factors that were taken into account in the consideration. And finally, the sanction, I should say, consideration of an appropriate sanction, and then finally the sanction is imposed. There were some cross-cutting and legal arguments during the proceedings that we had to deliberate on and rule on. The following cross-cutting issues and legal arguments were raised and were resolved as follows. And we're going to go through them one at a time. Firstly, there was an argument that the disciplinary proceedings were not validly instituted in accordance with the ANC Constitution. Our response to that is 1, the respondents argued that a resolution of this argument, if upheld, would not only put an end to the disciplinary proceedings against him, but also against the other members. In this case, the him refers to the Comrade Julius Malema, but also against the other members of the Youth League who have been charged. 2, in the view of the National Disciplinary Committee, this argument encompasses 2 aspects. Firstly, whether the ANC Constitution makes provision for a structure known as the national officials, and secondly, if so, did the national officials have the power not only to refer, but also to institute disciplinary proceedings. 3, the charges were instituted by the national officials, and the existence of the national officials as a structural organ was disputed by the respondents. After analysing the ANC constitution and the appendix, the NDC concluded that, firstly, it can be inferred that an organ exists in the ANC known as the national officials, which is distinguishable from the National Executive Committee and the National Working Committee, and that such organ has the powers conferred on it in terms of Rule 25(6)(a), read together with Clause 3 of the Appendix of the Constitution. Clause 3 of the Appendix to the ANC Constitution empowers the NDC to hear and decide cases referred to it by the national officials. I want to repeat, Clause 3 of the Appendix explicitly empowers the NDC to hear and decide cases referred to it by the national officials. The words, or the relevant body exercising its right to invoke disciplinary proceedings in Rule 25.3 includes the national officials, when read with the right of other organs such as the NEC to invoke disciplinary proceedings. Rule 25.3 confers 3 rights on the national officials, namely, firstly, to satisfy itself that disciplinary proceedings are warranted, secondly, to decide to institute disciplinary proceedings, and thirdly, to refer the matter to the NDC to proceed with such disciplinary proceedings. The argument that the national officials does not exist, and that if it existed, it could only refer and not institute disciplinary proceedings, was rejected. The second argument that was placed in front of the NDC was that the ANC Youth League is autonomous and therefore independent. In deciding this issue, the ANC took into account, firstly, the ANC's constitution, secondly, the ANC Youth League constitution, and thirdly, a document which was included as an annexure called A Life of Its Own, the Autonomy of the ANC Youth League, which was adopted at the 1991 National Congress of the ANC Youth League in Kwandebele, and then the evidence of the respondents' witnesses. In the understanding of 2 of the respondents' witnesses, the autonomy of the Youth League was qualified, but the Youth League had the freedom of organizational independence and the freedom to develop policy for consideration and possible adoption by the ANC. The Constitution of the ANC Youth League attributes the existence of the Youth League to the ANC and specifically provides that it shall be located within the overall structure of the ANC. This is reinforced by the dissolution clause, which provides, in the event of dissolution, that its assets shall vest in the ANC upon dissolution. The main objective of the Youth League is to support and reinforce the ANC, and Rule 7.4 of the ANC Constitution provides a constitutional mandate for the Youth League to achieve this objective. Comrade Winnie Mandela testified that the Youth League was autonomous in every respect except financially. Autonomous is defined in the ANC Constitution, and in the view of the National Disciplinary Committee, the operative word in the definition is operate, not the word independently. You read the Constitution, it will become clearer to you. The fact that the Youth League has chosen in its Constitution to be a legal persona that would enable it to hold and alienate property and enter into agreements does not make it independent of the ANC. These powers, in the view of the NDC, speak to a degree of organizational independence. This organizational independence is in turn circumscribed by Rule 7.4 of the ANC Constitution, which provides that the Youth League Constitution shall not be in conflict with the ANC Constitution and policies of the ANC. Moreover, Article 11.2 of Schedule A of the Youth League Constitution expressly subjects Youth League members to be sanctioned by disciplinary committees of the ANC and the Youth League by virtue of this provision. in effect, undertakes to ensure its enforcement. In the NDC's view, this provision on its own detracts from the argument that the ANC Youth League is independent. In summary, if the ANC Youth League seeks to operate outside of the ANC constitution and policy, it will, in the NDC's view, be acting outside the constitutional doctrine of legality of the ANC constitution and existing ANC policy. In other words, the ANC Youth League would, in that event, be operating unlawfully. On an analysis of all the evidence, the NDC is of the view that the ANC Youth League, like the Women's League and Veterans League, has a degree of organizational autonomy but is not independent of the ANC. Consequently, the respondents' defense that the ANC Youth League is autonomous and therefore independent of the ANC is rejected. The third argument was that the ANC deals differently with alliance partners and autonomous bodies and is therefore inconsistent. Put simply, the argument is that the ANC treats its alliance partners, COSATU and the South African Communist Party, differently from the Youth League, and by virtue of this conduct is inconsistent. This argument, in the view of the NDC, is misplaced for the following reasons. Firstly, both COSATU and the South African Communist Party do not derive their existence from the ANC constitution, as is the case with the leagues of the ANC. Secondly, COSATU and the SACP owe their existence and mandate to a different set of circumstances when compared with the Youth League as set out in its constitution. Thirdly, COSATU and the South African Communist Party have their own constituencies and programs and are accountable to their respective constituencies and not to the ANC, whereas the main objective of the Youth League, in terms of its own constitution, is for, this thing is quite chacharach, right? In terms of its own constitution, is for purpose of reinforcing and supporting the ANC. Allies come together for common purpose and the realization of common goals. Otherwise, they remain independent in the true sense of the word. On the other hand, the ANC Youth League, in terms of its constitution, owes its existence to the ANC and exists for the sole benefit of the ANC. Consequently, the NDC is of the view that the Youth League and the alliance partners, the ANC alliance partners, are not in the same relationship with the ANC. As such, any comparison as to how the ANC relates to the Youth League and its alliance partners to determine consistency is misplaced. In any event, the NDC is of the view that any value judgment about consistency or inconsistency can only be made over a period of time and after evaluating a number of events. Other than a reference to one incident concerning COSATU, the respondent has not provided any evidence of incidents over a period of time to enable the NDC or any reasonable observer to make a finding of inconsistency on the part of the ANC. The fourth argument that was placed in front of the NDC that the NDC is ruling on is the argument that the ANC Youth League has traditionally been militant and therefore the conduct of the current leadership cannot be judged differently. The NDC agrees with this proposition and does not believe that the current ANC Youth League administration should act or be judged any differently from previous administrations. The common denominator is that the ANC, for most part of its existence since 1912, has had a code of conduct to regulate the conduct of its members. In the view of the NDC, the decision whether to discipline or not lies in a fine line or threshold between militancy and robust expression on the one hand and ill discipline on the other. Once that line has been crossed or threshold breached, one could expect to be disciplined. All members of the ANC, without exception, are subject to the ANC Constitution and its Code of Conduct. All members of the ANC, without exception. In the NDC's view, ill discipline in the guise of militancy and robust expression cannot exempt any member from being sanctioned, nor can it be a license for reckless conduct. The fifth argument was that the disciplinary proceedings should not be used to settle political scores as provided for in Rule 25.2 of the ANC Constitution. The NDC agrees that the ANC Constitution expressly prohibits the use of disciplinary proceedings to stifle debate, deny any member of his or her democratic right, or be used to solve private problems. Generally, whether such prohibitions are in play can be established from the charge itself. For instance, if a member is charged for an utterance he or she never made, or an act that he or she never committed, but which is attributed to him or her in a charge, that allegation in itself should be sufficient for any disciplinary tribunal to be concerned about the legitimacy of the charge. In terms of Rule 25.2, such disciplinary tribunal is obliged to satisfy itself that the conduct of the charged member, which includes acts or utterances, constitutes a violation of the ANC Constitution or an offence affecting the organisation as expressly provided in Rule 25.2 of the Constitution. In the present disciplinary hearings, the respondents did not deny making the utterances which they were alleged to have made. In the face of such formal admissions, there was no rational basis or need thereafter for the NDC to consider whether the disciplinary proceedings were instituted for any illegitimate purpose. And we want to assure all of the members of the public that this National Disciplinary Committee has conducted its affairs properly, with diligence, with integrity, and there's been no undue pressure placed on this National Disciplinary Committee from any source at any point. The sixth argument was that the Youth League members would still retain their membership and positions in the Youth League, even if expelled from the ANC. Now, this submission was based on Rules 7.4 and 7.5 of the ANC Constitution, which provides inter alia that the Youth League will function as an autonomous body and that members of the ANC Youth League over the age of 18 are expected to play a full part in the general political life of the ANC. The implication of this argument, as understood by the NDC, is that in terms of the ANC Constitution, members of the Youth League do not necessarily have to become members of the ANC. This is the argument that was presented. Consequently, it would follow, according to this argument, that if a Youth League member is a member of the ANC, the outcome of disciplinary proceedings against that member in his or her capacity as an ANC member would not affect that member's membership of the ANC Youth League. The NDC was of the view that this argument was untenable for the following reasons. Firstly, the issue of the Youth League's autonomy has been dealt with in this finding as we've presented it to you, and the NDC's conclusion was that whilst the Youth League enjoys a degree of organizational independence, it is not independent of the ANC. Secondly, the Youth League Constitution specifically provides in Article H that Youth League members over the age of 18 are obliged to join the ANC. Thirdly, it follows that a Youth League member over 18 years of age will not be permitted to remain in the Youth League unless he or she becomes a member of the ANC. This positive obligation to join the ANC is reinforced, in fact, in the preamble of the Youth League Constitution, which provides that the ANC Youth League derives its existence from the constitution of the ANC and exists as a mass youth formation of the ANC. Furthermore, and very importantly, Article 11 of the Code of Conduct of the Youth League, set out in Schedule A of the ANC Youth League Constitution, provides, firstly, a disciplinary proceeding of the Youth League may not interfere with a person's rights and duties as a member of the ANC unless such rights or duties are exercised in an ex officio capacity on behalf of the Youth League. And 11.2 is probably the crux of the matter. A person who has been found guilty by an ANC disciplinary proceeding resulting in the imposition of the penalties of suspension, temporary forfeiture of membership rights, or expulsion, such penalties shall have the same application in all structures of the ANC Youth League. This comes from the Code of Conduct of the ANC Youth League's constitution. 4 point, so these provisions of Article 11 therefore postulate two outcomes. Firstly, as set out in 11.1, is that the outcome of disciplinary proceedings conducted by the Youth League against any of its members will not impact on that member's rights and duties as a member of the ANC. This is disciplinary proceedings conducted by the Youth League. The only exception is where that member represents the Youth League in an ex officio capacity, in which event the Youth League may exercise its rights of deployment of that member by removing him or her and nominating another member in his or her stead. This means that the outcome of disciplinary proceedings within the Youth League will not affect that person's membership of the ANC. Disciplinary proceedings within the Youth League will not affect that person's membership of the ANC. However, the converse position set out in 11.2 subjects all members of the ANC Youth League to be bound by the outcome of ANC disciplinary proceedings. In other words, it is not a defense for a Youth League member charged by the ANC to raise the argument that a sanction imposed by an ANC disciplinary committee would not affect his or her status as a member of the Youth League. The ANC Youth League, by express provision in its constitution, has subjected its members to and has undertaken to respect the outcome of ANC disciplinary proceedings against ANC members who are also Youth League members. Consequently, a Youth League member, by agreeing to be bound by the provisions of Article 11.2, has consented to the jurisdiction of the ANC over his or her membership of the Youth League. It also means that the Youth League itself shall be under a constitutional obligation to give effect to any decision of an ANC disciplinary committee which affects its members, and to take all steps necessary to ensure that the sanction is enforced. The ruling of an ANC disciplinary committee against a Youth League member is not limited to expulsion, but extends to suspensions. Consequently, if the respondent is expelled or suspended by the ANC, that ruling would affect and be applicable to his or her membership of the ANC Youth League, and he or she would no longer be permitted to participate in the Youth League in any capacity. We turn to the hearings now, and we start with the first hearing, and that was a hearing involving 5 members. In this hearing, comrades Julius Malema, Ronald Lamola, Pule Mabe, Ciso Magaka, and Kenetswe Mosanogi were charged for contravening Rule 25.5Q of the ANC's constitution and Rule 25.50 for deliberately disrupting a meeting of the ANC national officials and for undermining the Secretary General of the ANC on the 8th of August 2011. The finding of the NDC is as follows. Firstly, it is unprecedented and untenable for obvious reasons for a person or persons to enter a meeting of the national officials, which included the President and Deputy President of both the ANC and the Republic of South Africa, without prior invitation and permission. Secondly, the charges against the respondents were properly instituted by the national officials in terms of the ANC constitution. Details are set out in the disciplinary inquiry of Comrade Julius Malema, which is incorporated as part of its findings, and that is on the proper institution of disciplinary proceedings by the national officials. The NDC accepts that the respondents may have harbored feelings of frustration, and they could have held perception that they were not being taken seriously by the national officials. But the NDC finds that ill discipline is not a cure for frustration. The respondents' act of disobeying the directive of the national officials as conveyed to them by the Secretary General constitutes a breach of Rule 25.50 CC of the ANC Constitution, because such disobedience undermined the effectiveness of the ANC as an organization as contemplated in that sub-rule. The act of going to the meeting of the national officials uninvited constitutes a breach of Rule 25.5Q on the ground that such action was deliberate, disrupted the meeting of the national officials, and interfered with the orderly functioning of the ANC as contemplated in that rule. The NDC is satisfied that the complainant has proved its case on a balance of probabilities and that the causal link between the misconduct of the respondents and the acts of misconduct contemplated in Rules 25.5Q and Rule 25.50 CC of the ANC's Code of Conduct has been established. Could you open that for me, please? Thank you. Accordingly, the NDC finds the respondents guilty as charged. The impact of the ANC disciplinary proceeding on membership of the ANC Youth League, and we're going to go through that now. As argued previously, the pursuant to Article 11.2 of Schedule A of the Constitution of the ANC Youth League, this ruling is applicable to the respondents' membership of the ANC Youth League. Now we turn to the sanction. In all cases, we take various factors into account for the purpose of sanctioning, and I'm going to list them. Firstly, the seriousness of the charge, thank you. Secondly, the presence of aggravating factors. Thirdly, any previous findings against the respondents. Fourthly, the presence of mitigating factors. Fifth, the concept that the sanction must take into consideration the interest of the ANC, the respondents, and society at large. And then that the concept of a graduated approach to sanctioning must be followed, and the sanction must fit the offence. Now, in consideration, in this particular case, of an appropriate sanction, we would like to say the following. One, like any other organization, there is an unwritten culture of respect in the ANC. One sees it in practice every day. For instance, older members of the ANC are shown respect in the organization, irrespective of their positions in the organization. It is unfortunate that the respondents did not respect this culture. Two, cabinet ministers and other key officials of government are generally afforded security protection because any serious physical injury to them, or even death, could have a destabilizing effect on the country and on government's ability to discharge its mandate. The respondents, as senior leaders of the ANC Youth League, should have realized the security risk their action posed, and in this regard, the misconduct of the respondents is regarded as a serious offence. The ANC, as a liberation movement and the ruling party of a sovereign state governing the lives of about 50 million people, is expected to conduct its business in a professional manner. Discipline is necessary for the ANC to function optimally. South African society and the international community expect no less. The NDC took the view that the respondents, as ANC members and senior leaders of the ANC Youth League, are expected to shine as beacons of the values of the ANC and set an example to the millions of young people in South Africa, both black and white. It is the responsibility of the Youth League leaders to represent the hopes and aspirations of the youth of South Africa. The starting point on this journey is to acknowledge discipline as the foundation for any intended program of action. As potential future leaders of South Africa, the respondents have the responsibility of sending a strong signal of maturity and respect for authority. In the view of the NDC, this would be an appropriate moment for the respondents to reflect and stop their ill discipline. The letter of apology from the respondents was accepted as a mitigating factor. Now, having considered all these factors, the NDC imposes the following sanction. Firstly, the membership of Comrades Julius Malema, Ronald Lamola, Pule Mabe, Ciso Magaka, and Kenetswe Musanochi is suspended for 2 years. But more to follow. The sanction as read out to you, is suspended for a period of 3 years and will be implemented if the respondents are found guilty of any contravention of the ANC's Code of Conduct within the set period.
Can we disturb your chair?
Yes.
We will clearly request
Thank you.
that we listen to the presentation by the NDC and not make any howling, because we have invited the press here, and will request security to please take out any people who are making these noises that are really not warranted. Thank you very much. Thank you, Chair.
Thank you. I'm sure the media are going to be beacons of discipline and examples of the highest level of discipline. I'm going to reread just these sanctions. The membership of the 5 charged members then is suspended for a period of 2 years, but that sanction is suspended itself for a period of 3 years and will only be implemented if the respondents are found guilty of any contravention of the ANC's Code of Conduct within the said period. Pursuant to the provisions of Article 11.2 of Schedule A of the Constitution of the ANC Youth League, this ruling is applicable to the respondents' membership of the ANC Youth League. The NDC calls on the leadership of the ANC to ensure mentorship and nurturing of the ANC Youth League leadership as part of remedial action. The respondents, as in all cases, have the right to appeal to the NDCA within 14 days. We now turn to the second hearing involving Comrade Ciso Magaka. The respondent, Comrade Ciso Magaka, was charged for contravening Rule 25.50 of the Constitution of the African National Congress by, in a premeditated manner, prejudicing the integrity or repute of the organization by making derogatory remarks about an NEC member, thereby creating division within the ranks or membership of the ANC. The alleged act of misconduct was that on the 2nd of August 2011, he issued in the name of the ANC Youth League a derogatory statement regarding Comrade Malusi Gigaba, a member of the NEC and a cabinet minister. Comrade Shivambu and Tulelu testified on behalf of the respondent. The respondent himself did not testify. The findings of the NEC. After considering all the relevant factors, the NDC finds as follows. Comrade Shivambu contradicted himself in a material respect regarding a meeting that had been arranged between Comrade Gigaba and the Youth League. Comrade Shivambu's evidence about having confirmed what Comrade Gigaba had said at the American Chamber of Commerce is simply hearsay. The contents of the statement was derogatory and potentially inflammatory or defamatory in nature and constituted an unwarranted and unjustified attack on the person of Comrade Gigaba. As such, there was no obligation on the respondent to issue the statement in his official capacity as Secretary General of the ANC Youth League. The respondent would have had a valid reason or excuse not to issue the statement. The fact that the respondent elected to issue the statement in his name through his office as Secretary General shows that he acted with no consideration for the consequences of his action. By electing to issue the statement with full knowledge that its contents were derogatory of Comrade Gigaba, the respondent's conduct was unreasonable and in conflict with the ANC Constitution. The respondent, by conduct, associated himself with the contents of the statement and consequently attracted personal liability. Moreover, Comrade Shivambu testified that the statement was prepared by the leadership of the ANC Youth League, of which the respondent is part. Even if the statement was issued in the name of the respondent without his knowledge, which is not the case, there's no evidence before the NDC that the respondent had taken any immediate corrective action to absolve himself from liability after establishing that the statement had been issued. It is self-evident then that the issuing of the statement by the respondent was firstly prejudicial to the integrity and repute of the ANC and its personnel, namely Comrade Gigaba. Secondly, that it created or had the likely effect of creating divisions within the ranks of the ANC and in the ANC's relationship with the ANC Youth League, since the respondent, Comrade Gigaba, and the National Executive Committee members of the Youth League are all members of the ANC. Thirdly, it undermined the effectiveness of the ANC as an organization in that the respondent's misconduct undermined Comrade Gigaba's position as a minister deployed by the ANC within the country and internationally, And fourthly, it impeded Comrade Gigaba's activities in his capacity as a Minister of State and, by implication, the activities of the ANC as an organisation. On the evidence, the NDC finds the respondent personally liable for misconduct. The NDC is of the view that the complainant has proved the misconduct of the respondent on a balance of probabilities. The NDC is satisfied that the causal link between the respondent's misconduct and the act of misconduct contemplated in Rule 25.50 of the ANC Constitution has been established. For these reasons, the NDC is of the view that the defence of the respondent that he issued the statement in his official capacity as Secretary-General and as a representative or agent of the ANC Youth League and was therefore not personally liable cannot be sustained. Accordingly, the respondent is found guilty as charged. On the 6th of November 2011, the respondent's representative specifically requested the NDC to decide whether the disciplinary proceedings were validly instituted in accordance with the ANC Constitution. This argument was considered in the disciplinary inquiry of Comrade Julius Malema and in the finding of that case. The respondent's argument that the national officials, as we've already said, as a structure does not exist, and that if it existed, it could only refer and not institute disciplinary proceedings is rejected, and that is incorporated in this finding. Pursuant to the ANC disciplinary proceedings and the impact thereof on membership of the ANC Youth League, this ruling is applicable to the respondent's membership of the ANC Youth League. The various factors were taken into account for the purposes of sanctioning, identical to the previous case. We won't list them now. In consideration of an appropriate sanction, firstly, we said the Ministry of Public Enterprises is a critical portfolio in South Africa's quest to attract foreign and local investment for infrastructure development and job creation. The respondent, as a member of the NEC of the ANC, should have been familiar with programs of the ANC and government in this regard and should have realized the consequences of his action and its impact on society. The unwarranted attack on the person of Comrade Gigaba belittled and had the effect of potentially defaming him as a person. At an operational level, the attack painted a picture of someone who was ineffective, out to appease the forces of imperialism, and as one who did not enjoy the confidence and political support of his comrades in the ANC. In the NDC's view, this picture would have seriously lowered Comrade Gigaba's esteem, detracted from his mandated duties as Minister of Public Enterprises, and impacted negatively on the ANC. In the current economic climate internationally, the securing of foreign direct investment has become extremely challenging and competitive. The NDC is of the view that the respondent's action has prejudiced the ANC, the government, and the community it serves, including a possible negative effect on investment in South Africa. The NDC has taken cognizance of the fact that the respondent's conduct not only attracted liability to himself, but also created uncertainty and attracted risk to the country. International and local investors would be reluctant to enter into any long-term investment arrangements with a Minister of Public Enterprises who apparently did not enjoy the support of the Youth League of the ANC, who could be seen as future leaders. In any event, any attack on a leader of the ANC and NEC member by a Youth League leader who is also a member of the NEC constitutes an act of ill discipline and has the effect of creating divisions in the organization. For these reasons, the NDC considers the offence to be of a serious nature. The respondent did not testify. Consequently, the NDC has no basis to establish his version and consider any mitigating factors. The NDC has taken into account the finding of guilt against the respondent on the earlier charge, but has decided not to invoke the suspension in that matter for the purposes of determining an appropriate sanction in this case. Having then weighed and considered all these factors, the NDC imposes the following sanction. Firstly, the respondent's membership is suspended for a period of 18 months. Secondly, the sanction imposed shall be suspended for a period of 3 years and will be implemented if the respondent is found guilty of contravening Rule 25.50, which is the rule that was contravened in this case, of the ANC Constitution within the said period. Very similar to the previous case, the respondent's membership is suspended, but this sanction shall be suspended for a period of 3 years. And then pursuant again to Article 11.2 of the Constitution of the ANC Youth League, this ruling is applicable to the respondent's membership of the ANC Youth League. The respondent shall make a public apology to Comrade Malusi Gigaba. Failure to do this within 5 days after the conclusion of the disciplinary processes will result in Clause 9.1 taking immediate effect. The respondent shall be entitled to appeal to the NDCA within 14 days. On the third matter, and that is the case involving Comrade Shivambu, in this hearing, Comrade Floyd Shivambu was charged with 3 instances of misconduct. The first charge was for contravening Rule 25.50, AA, BB, CC, and DD of the ANC Constitution by prejudicing the integrity or repute of the organization, its personnel, or its operational capacity by impeding the activities of the organization, creating divisions within its ranks or membership, doing any other act which undermines its effectiveness as an organization. Now we'll deal with each of the acts of misconduct one at a time. On the first act of misconduct, the first act related to the respondent repeatedly swearing at a journalist on or about the 12th of July 2011, thereby causing harm to the integrity and reputation of the ANC. The second act of misconduct related to the issuing of a press statement in which inter alia the following is stated, and we quote, "The ANC Youth League does not believe that our position on Botswana and the approach is inconsistent with the ANC policy outlook, that if there's anything inconsistent with ANC policy directives, it is leaders of the ANC who associated with imperialist-controlled political parties like MDC in Zimbabwe and BDP in Botswana, and further that the ANC Youth League takes a practical program of liberating the people of Botswana from imperialist dominance, and further that the government of Botswana had openly embraced imperialism. And finally, that the resolution of the ANC Youth League NEC on the Botswana command team stands until there is a discussion with the ANC constitutional structures on what should be the approach to the Botswana question. The second charge levelled against the respondent was for contravening Rule 25.5I of the Constitution of the African National Congress by behaving in such a way as to provoke serious divisions or a breakdown of unity in the organization. The respondent was charged for misconduct for driving a wedge between the spokesperson of the ANC and the ANC officials in a press statement issued on the 2nd of August 2011, and the charge is that he undermined the leadership of the ANC and provoked serious divisions. Now, the finding on the first charge and the first act of misconduct under charge 1, the respondent admitted swearing at the journalist, and the NDC finds that the respondent uttered the foul language alleged in the charge. 2, the respondent's defense that he was provoked is rejected on the following grounds. Firstly, on the respondent's own evidence, the trigger for uttering the profanities was that the journalist had called him a fool. When compared with the respondent's previous encounters which taxed his patience, particularly being told that you Youth League people are corrupt, the NDC finds that the respondent's response was, in the circumstances, quite unjustified. Moreover, on the respondent's own evidence, he uttered the profanities after 8 or 9 telephone calls from the journalist, whose number he recognized and who, at the time of the call in question, spoke in a calmer manner, in a calmer voice. On the respondent's argument that the evidence was illegally obtained, the NDC finds that, firstly, the transcript of the taped telephone conversation by the journalist was not used to charge the respondent, nor was it used to make a finding or used to obtain evidence to secure a finding adverse to the respondent. Secondly, the respondent admitted that he uttered the profanities which he considered to be unfortunate and wrong, and the NDC finds him guilty on his admission and not on the evidence of the taped telephone conversation. The NDC rejected the respondent's argument that he could not be sanctioned twice for the same offence, the so-called defence of double jeopardy, on the following grounds. The defence of double jeopardy was not raised as a special plea in the proceedings. The respondent's reason for not doing so was that he was not sure of the legalities. Well, that might be so, but he was legally represented. The Youth League Constitution considers offences which damage the integrity of the organisation to be within the scope of offences which are considered to be grave, serious, and a violation of discipline, all of which would warrant a disciplinary inquiry by the Youth League. It is common cause that the Youth League did not convene a disciplinary inquiry but reprimanded the respondent. The NDC finds that the sanction of reprimand was not the outcome of a formal disciplinary hearing by the Youth League. The defence of double jeopardy is therefore rejected. The respondent's use of vulgar language constituted behaviour which is a breach of the ANCY's code of conduct. The NDC took the view that the media and any other third party with whom the respondent, as spokesperson of the ANC Youth League, communicated with deserved respect. Irrespective of how frustrated the respondent felt, it did not justify the behaviour that brought the ANC into disrepute. Based on his admission, the NDC finds that the respondent is guilty of prejudicing the repute of the ANC in contravention of Rule 25.50 of the ANC Constitution, and that the causal link between the misconduct of the respondent and the act of misconduct contemplated in Rule 25.50 of the ANC Constitution has been established. On the second act of misconduct, the contents of the statement which was submitted, issued by the respondent, raised the following contentious issues and was a contravention of ANC policy. Firstly, the statement disagreed with the ANC's spokesperson's approach and, by implication, the ANC's approach on Botswana. Secondly, it made reference to a practical program of the Youth League to liberate the people of Botswana from imperialist dominance. Thirdly, it referred to the BDP as a potential security threat to the entire African continent. Furthermore, it expressed the belief that the ANC Youth League's position on Botswana was not inconsistent with ANC policy. It stated that the ANC was acting outside its own policy directives by associating with imperialist-controlled political parties like the MDC and the BDP in Botswana. It further suggested that the ANC was establishing strange ideological trends and political relations for purposes of convenience, and that such conduct had the potential of undermining the integrity of the ANC as a national liberation movement. It issued a threat, namely, that the ANC Youth League resolution would stand until there was a discussion with the ANC on what the approach to the Botswana question should be. And finally, it stated that the ANC Youth League had canvassed and obtained the support of continental and world youth formations for its positions on Botswana. The respondent, by conduct, associated himself with the contents of the statement of the ANC Youth League, which was unlawful and unreasonable. The respondent's act of issuing the statement, without due regard for the consequences of his action, and in circumstances where he was under no obligation to issue the statement, rendered him personally liable for misconduct. The NDC is satisfied that the complainant has proved its case on a balance of probabilities and that the causal link has been established. Consequently, the NDC finds the respondent guilty as charged on charge 1, which consists of 2 acts of misconduct. On charge 2, evidence was presented for the complainant. Comrades, the national chairperson of the ANC, Comrade Mbete and Comrade Ntembu, testified for the complainant. And in view of its finding on this charge, the NDC believes it is unnecessary to summarize the evidence. The respondent is found not guilty of charge 2. The same applies in terms of the impact of ANC disciplinary proceedings on membership of the ANC Youth League. And I will now turn to the sanction. We've taken the same factors into account for the purpose of sanctioning, but in consideration of an appropriate sanction, this is what was considered in the first act of misconduct. Generally, a spokesperson is the face of any organization. The NDC is of the view that the respondent's use of vulgar language when dealing with third parties brought the ANC into disrepute is unacceptable and constitutes a serious offence. Comrade Mbete testified that she could not remember when the ANC had condoned such language and that it was not the first time that the respondent had committed such an offence. The respondent's apology to the Youth League for swearing at the journalist was considered as a mitigating factor. On the second act of misconduct, the respondent is a senior member of the ANC Youth League and performs the crucial function of communicating and articulating decisions of the NEC of the Youth League to members of the ANC Youth League and to the public. The NDC is of the view that the respondent, who is currently serving a second term as the spokesperson and a leader within the ANC, should have known better. The NDC is of the view that the interest of the ANC has been severely prejudiced by the misconduct of the respondent. Consequently, the organization's standing in inter-party and international relations has been eroded, and the element of trust and the ANC standing built over the years could take time to heal. As the ANC is the ruling party in government, the NDC has no doubt that the respondent's act of misconduct would have a negative impact on international interstate relations and would be prejudicial to society as a whole. The NDC is of the view that a key responsibility of spokespersons of structures and organs of the ANC is to disseminate and articulate decisions of the movement with clarity, consistent with policies of the ANC. Certainty is important because investors form their opinion about South Africa from the statements issued by spokespersons. The respondent's reckless conduct not only attracted liability to himself, but also put the country at risk. The NDC is mindful of the fact that the ANC Youth League is robust in its manner of conducting its affairs and has developed a tendency of pushing the boundaries of policy formulation, as the respondent has testified. And the ANC would not expect its youth wing to act any differently. However, the NDC is of the view that a distinction must be made between robust expression on the one hand and recklessness and ill discipline in expression. It was incumbent upon the respondent as a senior leader of the Youth League to be mindful of this distinction at all times. The NDC is also of the view that the respondent should have realized that states guard their sovereignty jealously and that the ANC had given an undertaking in the Freedom Charter more than 60 years ago to respect this convention. Any message from the Youth League as a structure within the ANC could be perceived by the public at large to be a message representing the views of the ANC and by implication the government of South Africa. The NDC has noted the arrogance of the respondent and his response to the ANC that, and I quote, "The Youth League's position on Botswana will stand until resolved with the ANC and regards such conduct as an act of defiance and ill discipline." This arrogance and defiance, the NDC notes, is a far cry from the manner in which various leaders of the Youth League over the decades conducted their affairs in attempting to influence ANC policy and to contribute to the political and organizational work of the ANC and the life of the nation. Thank you. Once the ANC, through its headquarters, has pronounced on any matter, no structure or member may publicly contradict such pronouncement. In the circumstances, the NDC considers the two offences for which the respondent has been found guilty to be very serious in nature. Is it just me who is hot, or are you all hot? That's right. Okay, I turn now to the sanction. Having considered then all of the above factor, the NDC imposed the following sanction in respect of the 2 acts of misconduct of which the respondent has been found guilty. Firstly, the respondent's membership is suspended for a period of 3 years. Pursuant to Article 11.2 of the Constitution of the ANC Youth League, this ruling is applicable to the respondent's membership of the ANC Youth League. The respondent shall vacate his position as a member of the National Executive Committee of the ANC Youth League. The respondent has the right to appeal to the NDCA within 14 days. We now turn to the 4th hearing, the matter involving Comrade Malema. 3 charges were levelled against Comrade Malema. The first charge is for contravening Rule 25.5I of the Constitution of the ANC by behaving in such a way as to provoke serious divisions or a breakdown of unity in the organization. The second charge is for contravening Rule 25.5C of the Constitution of the ANC by behaving in such a way as to bring the organization into disrepute. And the third charge is for contravening Rule 25.5D of the Constitution of the ANC by sowing racism or political intolerance. Now, we just give you a brief prelude to the findings. As a prelude to the findings on the specific charges, the NDC finds that there is a difference between the Youth League as an institution and the respondent as an individual. In the same way, there is a distinction between the Youth League statement and the respondent's utterances. The NEC of the Youth League was not charged for its statement. It was the respondent who is being charged for his utterances. We turn to charge 1. Just to repeat, it is for behaving in such a way, for contravening Rule 25.5I of the Constitution of the ANC by behaving in such a way as to provoke serious divisions or a breakdown of unity in the organization. The finding on charge 1, the NDC finds that, I'm going to just elaborate on that first charge, that the charge relates to the Comrade Malema when addressing a press conference at the conclusion of the ANC Youth League NEC meeting on the 31st of July 2011. He actively participated in making the following statements. In the past, we know that President Mbeki used to represent that agenda, and it refers to other matters that were in front of us as a committee. And he further stated that the African agenda is generally no longer a priority, and we think that there's a temptation by the colonizer and the imperialist to want to recolonize Africa in a different but sophisticated way. And President Mbeki stood directly opposed to that type of conduct. Now, the finding on this charge is that the onus was on the respondent to explain the utterances which he admitted. Save for a bald denial that he was having a dig at President Zuma, the respondent has failed to discharge this onus and provide any reasonable explanation for his utterances. Given that the respondent was elaborating on the Youth League statement as he contended, then the inescapable conclusion is that the respondent accepted and associated himself with the Youth League statement, which attributed the existence of a vacuum and the decline in the African agenda directly to the departure of President Mbeki. It is this statement that the respondent was elaborating on. The respondent's evidence that the Youth League, and not him, suspected that the ANC and the South African government had relegated the African agenda when considered against the objective fact that President Mbeki had resigned 3 years ago in June 2008 is further support for the inference that the respondent was in fact negatively comparing different administrations and leaders of the ANC and the ANC-led government. The fact that Comrade Motlanthe and President Zuma are not mentioned by name in the respondent's utterances is immaterial and does not detract from the conclusion that the respondent was comparing different administrations. In the context of the respondent's utterances, reference to President Zuma is apparent by innuendo and supports the inference above. Comparison between different eras of leadership in the ANC's history by itself is not an act of misconduct, and in fact is part of our culture of democratic debate. However, the suggestion that the administrations after Comrade Mbeki have relegated or abandoned the African agenda and thereby aided and abetted the imperialist agenda that seeks to recolonize Africa is untrue and portrays the current ANC government and its leadership under President Zuma in a negative light, and therefore has the potential to sow division and disunity. On the respondents' own evidence about the performance of the ANC, South African government, SADC and the AU, the inference above excludes every other reasonable inference that could have been drawn from the respondents' utterances. The inference is consistent with all the proved facts. The respondent was personally liable for his utterances, and the NDC rejects the defense of the respondent that he was acting in a representative capacity or on behalf of the collective on the following grounds. Just to repeat, he's found personally liable, and the defense that he was merely acting in a representative capacity or on behalf of the collective is rejected on the following grounds. It would normally be the responsibility of the respondent, as he testified, to read the Youth League statement in his capacity as president of the Youth League. However, on this particular occasion, he was advised by the NEC of the Youth League not to read the press statement because the spotlight was on him, and he could be questioned on issues related to his family trust. For that reason, the Secretary General was mandated to read the Youth League press statement. Even if the respondent did elect to attend the press conference, he was under no obligation to answer any questions. He attracted personal liability when he voluntarily chose to answer questions at the press conference to elaborate on the Youth League statement, which was not within the parameters of ANC policy. By agreeing to be bound by the decision of the collective, the respondent by conduct associated himself with the decision of the collective. If that decision is subsequently found to be unlawful, i.e. if it constitutes a contravention of ANC policy or the ANC's code of conduct, or if it's found to be unreasonable, in other words, if it could expose the member of the collective to liability for misconduct for articulating the decision of the collective, then the respondent, by doing something or saying something in furtherance of the collective decision, attracts personal liability. I will just pause for a second. No, great. Good. This technology works pretty well. Then, having regard to the evidence of Comrade Montash and the respondent's own evidence, the respondent's behavior was directed at the leadership of the ANC and as such could potentially provoke serious divisions or lead to a breakdown of unity in the ANC. The complainant has proved, on a balance of probabilities, that the respondent's behavior constituted an act of misconduct as contemplated in Rule 25.5I of the ANC Constitution. The causal link between the respondent's behavior and the misconduct has been established by implication and on balance of responsibilities, and the respondent is therefore found guilty as charged on this charge. On charge 2, the second charge is for contravening Rule 25.5C of the Constitution of the ANC by behaving in such a way as to bring the organization into disrepute. And specifically, it refers to the 31st of July 2011 when he addressed a press conference where, in the name of the National Executive Committee of the ANC Youth League, a structure which operates within the policy confines of the ANC, he made the following pronouncements. Botswana's leadership of government poses a serious threat to Africa, so we need a progressive government in Botswana. And then he went on to say, we are not going to sit with neighbors that conduct themselves like that. Botswana is in full cooperation with imperialists, and the government is undermining the African agenda, and further, that the ANC Youth League would establish a Botswana command team which will work towards uniting all opposition forces in Botswana to oppose the puppet regime of Botswana led by the Botswana Democratic Party. These careless, negligent, or reckless pronouncements and utterances were a deviation of established and ongoing ANC policy and had the effect of embarrassing and bringing the organization into disrepute within and beyond the borders of South Africa. That was the charge. The finding of the charge, the NDC finds that the respondent, as a member of the NEC of the ANC, should... So we're dealing with this charge, which is the second charge. And the finding on this charge, the NDC finds that the respondent, as a member of the NEC of the ANC, should or ought to have known that the Youth League statement on Botswana was not part of or within the parameters of ANC policy. The respondent did not provide any additional explanation beyond stating that he uttered the words alleged in the charge to support the Youth League's decision to establish a Botswana command team. The respondent's utterances per se against a sovereign state were reckless and baseless pronouncements and impacted negatively on South Africa's relations with Botswana, SADC and the African Union, brought the ANC as a liberation movement and the ruling party in South Africa into disrepute, and were in conflict with ANC policies and the ANC's resolution on party-to-party relations as adopted at the 52nd National Conference in Polokwane. The respondents' utterances, as seen on the auto-visual clip, which was produced in evidence, that a team was to be sent to Botswana, or a team from Botswana would visit South Africa by the end of August, went beyond the ANC Youth League statement. It is indicative of a final decision that was in the process of being implemented and was his personal view. In the absence of providing a satisfactory explanation, the only deduction the NDC could make, either directly or through witnesses, was that the respondent was indeed expressing a personal view, since he was not reading out a statement. He was responding to questions and adding his own elaborations and his own replies to a press conference. By his conduct, the respondent associated himself with the contents of the ANC Youth League statement. By voluntarily choosing to amplify the Youth League statement, which was not part of or within the parameters of ANC policy, and where there was no obligation upon him to do so, the respondent acted recklessly and in contravention of ANC policy and the ANC's code of conduct. Even if it is to be assumed that the respondent acted in a representative capacity, then his utterances, which expressed a personal view, would still make him personally liable. The respondent's personal liability is founded on two acts of misconduct contemplated in Rule 25.5c of the ANC Constitution, both of which are deviation of ongoing ANC policy and which had the effect of bringing the organization into disrepute. His act of publicly uttering excerpts from the contents of the ANC Youth League statement, which was not part of and within the parameters of ANC policy. His utterances, which do not appear in and go beyond the Youth League statement, expressed a personal view and was in conflict with ANC policy. Having regard to the evidence of Comrades Mbete and Montash, the audio-visual clip and the respondent's own evidence, the complainant has proved that the respondent's utterances were reckless and a deviation of ongoing ANC policy, that the respondent brought the ANC into disrepute, and that the respondent's behavior constituted misconduct as provided for in the ANC's constitution. The complainant has proved its case on a balance of probabilities, and the causal link between the misconduct of the respondent and the contravention set out in Rule 25.5c of the ANC Constitution has been established. The respondent is therefore found guilty as charged, under charge 2. The third charge was for contravening Rule 25.5d of the Constitution of the African National Congress by sowing racism or political intolerance. This charge relates to the statements made by the respondent at a public rally on the 9th of May 2011 in Khalishiwe. There was also an alternate charge of contravening Rule 25.5c of the Constitution of the ANC by behaving in such a way as to bring the organization into disrepute. The finding on this third charge, the NDC finds, after evaluating all the evidence, the complainant has not proved its case on a balance of probabilities. The respondent is found not guilty on this charge. The evidence of the complainant does not support the alternative charge of bringing the ANC into disrepute, and the respondent is accordingly found not guilty also on the alternative charge. Turning now to the sanction, again we take the factors into account, and I think I'll just read them again to refresh your memories. We take into account the seriousness of the charge, the presence of aggravating factors, any previous findings against the respondent, the presence of mitigating factors, the concept that the sanction must take into consideration the interests of the organization, the respondent and society at large, the concept of a graduated approach to sanctioning, and that the sanction must fit the offense. In consideration of an appropriate sanction, these were some of the matters which the NDC took into consideration. Firstly, as the president of the ANC, of the Youth League, the respondent had a duty to lead and direct the Youth League and to focus on the League's constitutional mandate in terms of Rule 7.4 of the ANC Constitution, namely to confront and champion the issues facing the youth and to ensure that the youth make a full contribution to the work of the ANC and to the life of the nation. This places an obligation on the leadership of the Youth League to prepare its membership for active participation in the mother body and to defend the constitution of the ANC, its values and its policies. Outside the core constitutional mandate of the Youth League, it was and still is open to and expected of ANC Youth League to push the boundaries of policy formulation within the ANC on any policy issue, as it has done historically, in order to make a full contribution to the work of the ANC and the life of the nation, provided that such lobbying is done within ANC policy and procedure. The fundamental goal of the ANC remains the creation of a united, non-racial, non-sexist, democratic and prosperous South Africa. Non-racialism was and still remains the driving force for the formation of the existence of the ANC. In the furtherance of this objective, the respondent has an obligation to shy away from sowing division and disunity in the ANC. In the view of the NDC, the respondent, as the leader of the Youth League, should have focused his energy on developing programs to actively reach out to the broad cross-section of the youth, both black and white, so that the Youth League of today would be at the forefront in cementing the foundation of tomorrow's non-racial and non-sexist society. The NDC is also of the view that the respondent should have realized that states guard their sovereignty jealously and that the ANC had given an undertaking in the Freedom Charter more than 60 years ago to respect this convention and to respect the right to peace and friendship and self-determination of all nations. As the ANC is the ruling party in government, the NDC has no doubt that the respondent's misconduct would have a negative impact on international and interstate relations and would be prejudicial to South African society as a whole. The acts of misconduct for which the respondent has been found guilty are very serious and have damaged the integrity of the ANC and South Africa's international reputation. In May 2010, the respondent was found guilty of contravening Rule 25.5I of the ANC Constitution, and the sanction imposed inter alia was that should the respondent be found guilty of contravening Rule 25.5I of the ANC Constitution within the next 2 years, his membership of the ANC shall be summarily suspended for a period to be determined by the NDC. The ANC Youth League is the preparatory school for future activists and leaders of the ANC. Discipline is a core attribute of any leadership, and the ANC would have expected the respondent to have led by example. In the space of a year and a half, the respondent has been found guilty on 4 acts of sowing division in the ANC, bringing the ANC into disrepute, and defying the national officials. The NDC is of the view that at its most fundamental level, the ANC is a voluntary organization which people join willingly because they subscribe to its aims, objectives, culture, ideals, and value system. This is the glue that has held the ANC together for almost 100 years. No one is forced to join the ANC or compelled to remain in the ANC if he or she is not happy. In the same spirit, the ANC should not be obliged to retain the active membership of any person, without exception, who pays scant regard to the membership oath of the ANC, its policies, organizational culture, value system, and code of conduct. We turn now to the sanction. Having considered all of these factors, the sanction imposed on Comrade Julius Malema is as follows. Firstly, with regard to the respondent's disciplinary hearing in May 2010, the respondent's membership is suspended for a period of 2 years. In respect of the present disciplinary hearing, the respondent's membership is suspended for a period of 5 years. The sanction imposed in respect of the earlier disciplinary hearing and the present disciplinary hearing shall run concurrently. Pursuant to Article 11.2 of Schedule A of the Constitution of the ANC Youth League, this ruling is applicable to the respondent's membership of the ANC Youth League, and the respondent shall vacate his position as president of the ANC Youth League. The respondent has the right to appeal to the NDCA within 14 days. Thank you very much. I just want to use this opportunity to thank all of the members of the committee. I think there's been a lot of strain on the members of the committee. There's been a lot of hard work. The committee has worked with integrity and tirelessly and has upheld the principles of fairness and procedural correctness throughout. And so I do want to thank them, and we would like to thank Comrade Krish Naidu, who has been acting as a note-taker to the committee. Thank you very much.
Just a minute, please. Just a minute. I thought journalists understand how we conduct press conferences. Thank you very much, Comrade Derek and your team, for this very extensive press briefing. We will now do what we normally do before people jump the gun. We will ask those who would like to.
Well, there you have it, the verdict of the National Disciplinary Committee of the ANC. Of course, that last ruling there affecting the president of the ANC Youth League, Julius Malema, who will have to vacate the position of president of the ANC Youth League. Of course, he does have 14 days within which to appeal that decision. Well, joining me now is, of course, political analyst Dr. Somadoda Mafikeni, who has been following these events and who has been quite close to this process and who has a much better understanding of the rules of the ANC, the conduct of the ANC, the history and practices of that organization. Let's start with the last one, Dr. Figeni. Julius Malema being asked to vacate the position of president of the ANC Youth League. Of course, he does have room to appeal. What do you think that's going to happen? That's going to do to him?
Well, I think it will send the shock waves around that the maximum sentence that was expected was the one that they pronounced on. We expect his legal team to appeal within 14 days, but at the same time, I think the Youth League leadership will have to make a determination whether they will respect the outcome whilst they are having an appeal or simply mobilize outside the ANC framework.
Well, I mean, judging from certainly what some youth league members, I mean, when we're preparing for this morning's events, I mean, we went through quite a number of clips from ANC youth league members who were saying, guilty or not, they are going to support Julius Malema because they do believe that everything he has said is actually what the youth league mandated him to do and to say.
Well, that will depend on whether the leadership across provinces remains united in supporting him. Then that will pose a political dilemma for the ANC because it would have to institute several disciplinary actions. It will also depend on whether the ANC leadership itself remains united in accepting the verdict or they begin to show some fragmentation where other leaders begin to disagree with the outcome. That in itself, again, will impose a political challenge to the ANC itself.
Well, I mean, just listening to Derek Hanekom elaborating on how they arrived at the conclusions that they arrived at, do you think that perhaps there are holes that they can punch? In other words, there are holes that people who disagree with what was said with the ruling today, are there holes that they can punch in everything that was said today?
To the extent that ANC for a very long time had allowed discipline to dissipate, the holes that could be punched would be the ones of consistency because Malema was allowed quite a long rope to do exactly the same things of dividing the organization. But when it was against the leadership of ANC leading to Polokwane, it was somehow tolerated in a sense. And again, there are many instances, whether at branch levels, regions, where such ill-disciplined divisions had been allowed. Now ANC will have to work very hard beyond this case to restore discipline across the board, no matter who is there with which constituency. If that consistency is there, over time they may win the battle, but if on one occasion they allow some of these activities to fester, it will be a problem. But the other point which I thought was now alluding to political statement is when he would be saying some of the actions of Malema were threatening the investors, and that in itself might then be disputed because you have different leaders feeling differently on how certain policy decisions are taken. I wish they could have just restrained themselves to the charges without making those statements.
But I mean, it's quite interesting though, because I mean, in certain parts of the ruling, or should I say the rulings, he did allude to the fact that the NGC took a decision that ill discipline can no longer be tolerated, and that whereas before people tended to condemn and did nothing about it afterwards, in other words, to the people who transgressed, that had to come to an end. So to that extent, he does. I mean, the disciplinary committee did sort of cover themselves, didn't they?
Well, watch the space when there was a build-up to the local government elections and the list processes. The number of instances where disruptions, ill-discipline utterances took place, they would then have to go back to those members and discipline them as well, because that took place after the NGC. So that's why I'm saying the issue of consistency will be critical in this instance.
Well, which brings